Welcome to the channel where we break down key real estate concepts to help you navigate your transactions with confidence. Today, we're diving into a topic that often surprises people: oral contracts in real estate. You might think everything has to be in writing, but that's not always the case. Let's talk about what oral contracts are, when they might come into play, and why you should be cautious when relying on them. When it comes to real estate transactions, most people think of written contracts as the standard. But did you know that oral contracts can also be legally binding in certain situations? Let me explain what that means. An oral contract is essentially an agreement made through spoken words, without anything written down. In real estate, oral contracts might come into play in situations where parties make verbal agreements about certain terms of a transaction. For example, you might verbally agree with a seller on a purchase price or with a landlord on rental terms. However, there are significant limitations and risks when it comes to oral contracts in real estate. The biggest issue is enforceability. While oral contracts can be legally binding, they are often difficult to enforce because there's no written record of what was agreed upon. In the event of a dispute, it can be challenging to prove what terms were discussed and agreed upon, making it a he said, she said situation. In real estate, the statute of frauds plays a crucial role. This legal principle requires certain types of contracts to be in writing to be enforceable. In most states, this includes contracts for the sale of real property, leases longer than a year, and other significant agreements. So, even if you make an oral agreement, if it falls under the statute of frauds, it may not hold up in court unless it's put into writing. Because of these limitations, relying on an oral contract in real estate is generally not advisable. It's always better to get agreements in writing. This protects both parties by clearly outlining the terms, conditions, and obligations, reducing the likelihood of misunderstandings or disputes down the line. As an agent, my advice is to ensure that any agreement related to real estate is documented in a written contract. This not only provides a clear record of the terms but also ensures that your interests are protected. If someone proposes an oral agreement, it's important to follow up with a written contract that captures everything discussed. In summary, while oral contracts can technically exist in real estate, they come with significant risks. To safeguard your interests, it's crucial to rely on written agreements that clearly define the terms of any real estate transaction. Thanks for watching. I hope this explanation helped clarify the risks and realities of oral contracts in real estate. If you found this video helpful, be sure to give it a thumbs up, subscribe for more real estate insights, and leave a comment if you have any questions. Until next time, make smart, informed decisions in all your real estate dealings.